SJC-13734, Stephen E. Stone, trustee and another, versus Zoning Board of Appeals of Northborough and another.
Okay, Attorney Lanza.
Good morning. If it so pleases the court, my name is Mark Lanza. I represent the plaintiff's appellants. So we have another zoning case and another one that involves standing. But this one presents an issue that I don't think this court or the appeals court has ever addressed. So it's unique. I'll state it this way. When a judge, whether it's a trial or on summary judgment motion, is determining whether or not the presumption of standing that a party in interest enjoys has been rebutted by the opposing party, should the court consider the ordinary use of the project that's at issue, or some more limited use of the project that the developer represents is going to occur.
What evidence was there about ordinary use?
The ordinary use, the term warehouse is defined in the town zoning bylaws. It defines, what it is.
So what record evidence was there about the ordinary uses that you're contending should be considered?
It's in the zoning bylaws.
But the zoning bylaws aren't evidence about the ordinary uses to which this structure would be put and the effects thereof, right?
Well, it describes what warehouse uses are, what constitutes a warehouse use.
So
but was there evidence of a certain level of traffic for ordinary warehouse use versus a level of traffic that the developer said would occur with its planned use? No, there was no comparison. There was no evidence.
So do we look at the size of the warehouse, the number of bays in the warehouse, and the hypothetical warehouseness of it?
Yeah, and those are factors. I mean, and there are factors that the trial judge didn't consider. The trial judge
but here we're confronted with this e-commerce issue, which has light use as opposed to a concrete plant or a concrete, a normal warehouse.
And that's what the developer here represented would occur, a very light use, a few trucks a day, and I think one larger truck delivery per month. Now, if the Zoning Board of Appeals had included a condition in this decision, that's the traffic that you're limited to, I don't think we'd be here. But that isn't what happened. The application was for a 20,000 square foot warehouse with no specificity as to the type of warehouse uses. The zoning board's decision granted a use variance for that warehouse with no limitations on type of use, no limitations on traffic,
but
no conditions.
This is what happens during the zoning process. I mean, what the appeals court concluded, in which you cited as binding authority, which it isn't because it was just a three-person panel decision. You have a situation where the applicant says, here are my proposed uses for why I want the variance. It goes through all the public hearings, people get heard, and it's based on what they propose to be the use. This idea that now we have to kind of puzzle our way through the fact that they might say, I'm not going to use the 5,000 square feet, I'm going to make it into a club. I mean, that this is, how are we ever supposed to have a regulatory framework where now the zoning board or judges on review have to kind of look into the crystal ball as to all of the proposed ways that a particular applicant is planning to use it versus what they say they're going to do?
I don't think that the court has to look into all the particular ways or all the many ways. Here, it's a warehouse. A warehouse, and the bylaws say, here's what you can use a warehouse for. And you could have an applicant saying that the traffic that I'm going to generate is X, and the applicant and the abutter saying, no, that isn't what happens. We've got many warehouses in Northborough, and we do. Here's the traffic that's generated by those warehouses.
But they would have to adduce evidence of that. They just couldn't come in and say, oh, we think, right? They would have to adduce evidence to rebut what the applicant is saying about the proposed use and that it's not what they say it's going to be. And that really wasn't here, was it? I mean, your clients talked a lot about what they think and what they think their experience is going to be, but there really wasn't any evidence to rebut what the applicants had said, the proposed use and the trucks and the time and the limitations that were put on there, right?
Right, because how could they? I mean, how could they say that we know, or we're certain, or we're reasonably certain that there's going to be a different type of use? So you,
Whose burden is it to show standing?
it depends. Initially, in this case, my clients had the presumption of standing, so they had no burden to show standing.
And then it was rebutted.
Right.
It was, according to the trial judge, it was rebutted according
It
to my
was
clients.
rebutted based on the evidence. And now you're saying, there was no evidence of what this hypothetical warehouse usage ordinarily is.
No.
So back to my question, whose burden is it to show standing?
Again, it depends. If it's
No.
if it's shift
The presumption has been rebutted, who then bears the burden?
then the party claiming, the law is clear, the party
Your
claiming
clients.
then has the burden of showing standing.
Right.
And
So
again,
here we have a record that shows the presumption was given as abutters. It was rebutted by the actual use proposed by the applicant, and nothing, as far as I can tell, back from the abutters.
well, again, my client's position is the presumption was not adequately rebutted, and when that issue arises, whether the presumption is rebutted, that's not an issue that's suitable for summary judgment, and that's how this case was decided, on summary judgment. The trial judge went as
But
far
what
as
is
to...
the material, show me in the record where there's a material dispute of fact as to what the usage of this warehouse was.
Well, again, there's a definition of a warehouse.
And what is the traffic in that definition? What does it say?
There's no mention of traffic. It's
Okay, what is the noise in that definition?
There's no particular noise in that definition.
Okay.
If,
So-
I have two questions, I'm sorry,
And-
I don't, I have two questions for you. The first is that did you make below, in opposing the summary judgment motion, I didn't see that you had made the argument that the ZBA should have considered the potential future uses of the property. Am I correct? And if I'm wrong, could you please just give me the record site?
Oh, we didn't make that
Okay.
specific argument, no.
So,
Superior Court.
Right, so, and did you make that specific argument even in the appeals court?
Well, we made it, but not in exactly those terms. We made it,
Okay.
the same way we're making it here, that,
Right, but
you
it
know,
doesn't look like it was preserved in the trial court.
Yeah,
Okay, so that was my first question. My second question is, this is a use variance, correct?
that's correct.
A use variance, normally, if a party, it's granted based on the proposed use that the applicant is forwarding. And then if the applicant deviates in some meaningful way from that use, there's remedies for abutters and other people who are affected by that deviation, correct?
Correct, and
And
that's,
what are the normal routes for that?
that's one of the things that the developers argued here, that we have a remedy. So I would like to play that out, because it highlights the problem with the trial court's decision. So my clients are sitting in their living room, which is 80 feet from this warehouse loading dock, and instead of 3 vehicles a day, there's 100 vehicles a day. Instead of one large delivery truck per week or month, whatever the applicant said, there's 10, and there's backup beepers. And they're having a hard time enjoying the house. They're having a hard time getting to sleep. So they call me up, and they say, well, Mr. Lanza, we understand that we have the right to request enforcement. So I take a look at the zoning board's decision, and I say, okay, let me see here. What provision is the applicant violating? None, because it gives the applicant the right to operate a warehouse that's 20,000 square feet with no limitations on use, no limitations on traffic. So that highlights the
You're saying
problem.
you wouldn't be able to get the enforcement officer to issue a cease and desist.
Yes,
And then
I wouldn't
you
even
would-
be able to say, here's the provision of the
Well,
decision that's
you
being
would
violated.
make a request to the enforcement officer. The enforcement officer would refuse it, and then you would appeal back to the ZBA, correct? And at that point, you could raise this issue about the use variance and the bases that it was granted on.
Yes, we could.
So
and-
why,
And if dissatisfied, we could go to the courts. But again, the
right,
first
so
step
why
is,
isn't that the correct route rather than what happened here, which is to say that you have standing on unknown future possibilities?
whenever a party claims standing, there's always some degree of unknown, because the project doesn't exist yet, okay? So in some cases, you just have to use common sense, a truck, that's backing up with backup speakers, and you're 80 feet away, you're going to hear it. And in this court, and the appeals court has ruled on a number of occasions, in some cases, expert evidence isn't needed. And in this case, we didn't think it was needed. But to answer your question directly, Justice Wologian, if I'm mispronouncing your name, please excuse me. Again, I would have to look at the decision and say, what am I asking the zoning board or the zoning enforcement office to enforce? And the problem is, it doesn't say what the applicant wants us to think it says, okay? It doesn't describe a project, a limited project, that the applicant wants us to believe is going to be built. So, I mean, therein lies the problem. I think the court really should clarify this rule of law one way or the other. I've been doing handled a lot of zoning cases over the years, and this is the first time this issue has come up.
So
so
usually there's, in the variance, it says approved for these uses and sort of goes down, or is that how it usually works?
Yeah, it usually says a use, and then many times there's conditions, and many conditions sometimes. There's not one condition in this variance decision. And again, if it had the condition that the applicant would have you believe is really embedded or implied there, we might not be here.
Was that requested and denied? Were conditions requested?
I don't know, I was not at the zoning board.
But
proceeding.
there were other conditions from other boards, right? Wasn't there a condition from the planning board about the number of trucks or the time of trucks and all of these other, there were restrictions on the applicant here.
In the planning board special permit decision, not in the variance decision.
Agreed, but I'm saying that it's not, the idea that they had no guardrails whatsoever as it might impact your clients, the record doesn't really support that.
No, I'm not suggesting that. But what I'm suggesting is that this decision doesn't contain the conditions on use that the applicant suggests exist. And that's the problem.
But if the only reason why a variance is needed is to deal with the requirements of the overlay district, why would such a use variance then be required to list conditions that aren't related to the overlay district?
It wouldn't have to, but typically, again, I have a long background in representing municipalities, and I've written many decisions for zoning boards, planning boards. They typically will include conditions, not just for the particular use, but for its impacts and many other things. Is it required? No. Is it a good idea? Yes.
And you think that the board's findings of fact, which it does make, many of which concern the proposed use, would be an insufficient basis upon which to seek future relief
Yes.
through an enforcement action?
I'm looking at them. They're on page 287 of the record appendix. And, they don't really limit the project other than to say it's a 20,000 square foot warehouse with 3,000 square feet of office.
We've got the hearing on, right? We have all the details from the hearing. Work is distribution, sales, no customers will come to the building, and 2 to 3 UPS-like trucks daily will go to the site. You're going to be, if something new comes up, you're going to walk in with the hearing discussion and say, this is what they approved, aren't you?
No, because that's not in the findings, that's not in the decision, that's not in the conditions. That's just a narrative of what happened at the hearing. And it would be great if every applicant did exactly what they said at a hearing that isn't written in a land use board decision. It doesn't happen that way.
So your view is your client is exposed to this guy's going out and selling the warehouse to FedEx and having 8,000 trucks come a day, and he's not going to be able to, your client's not going to be able to go right back and stop that?
Yes, I'm very concerned about that, and having handled many zoning enforcement actions, defending zoning enforcement officers over the years, this would be a very difficult one. I would have a hard time. I'm not sure I'd even take the case because I don't feel I have an adequate, basis to say there's been a violation. You could say that, but it looks like I'm over my time.
Okay.
Thank you for hearing me.
Thank you. Attorney Brewer.
Good morning, Chief Justice, Justices of the Supreme Judicial Court. May it please the Court, my name is Donna Brewer, and I represent Cable Matters, Inc. I'd like to focus on the statute itself, on which this appeal is based, which is 40A, Section 17. It states right at the beginning, any person aggrieved by a decision of the Board of Appeals may bring an action within 20 days of the decision after the decision has been filed with the town clerk. In all of these appeals, the focus is on the decision of the special permit granting authority or the zoning board of appeals. In this case, the decision is expressly focused on and based on the proposed use. You have only to look at the decision itself. The proposed use is allowed by right. The proposed use will not be more detrimental. The proposed use is not more detrimental than a residential property. That is what the Zoning Board of Appeals was asked to. That's the scope of its review, and that's the basis of the decision. And it is the decision itself on which we judge whether these plaintiffs have been aggrieved. They have
to leap off, to start where we left off, if in the future, can you describe what would happen if there were use that were inconsistent with the proposal, but not necessarily inconsistent with the conditions about, no trucks after 8 p.m.?
So I submit that he's talking about the wrong board for that.
No, I understand that those are under a different permit, but under this, with the hypothetical, with the special permits in front of us now, what would happen if there were use that were different from what was proposed?
Yes, if there were uses beyond what the conditions of the planning board imposed in its decision, then yes, you can bring enforcement action. I also represent a lot of towns, and yes, you can bring an enforcement action with the building commissioner, and if you are unhappy with that enforcement actions go to the ZBA. If they don't enforce it, then it would go to the Superior Court.
But what's enforceable?
What's enforceable in that case are the conditions that were imposed on the special permit by the planning board.
And so the proposal itself is not limiting?
The proposal itself is not limiting, well,
Right,
it
so
may be.
unless there's a
It's-
condition here that limits the, trucks to once a day, whatever it is, the proposed use. There's no condition that's enforceable if the actual trucks and the actual traffic to and from the warehouse is more.
There are conditions that address all of that.
Okay, which
So
are
there
they?
are conditions that say the hours of delivery. There are conditions that say the flow of traffic, i.e. the traffic can only go out, it can only exit from the property to Lyman Street, but there's an entrance and exit on Bartlett Street. Bartlett Street is the busier road.
But I thought the de minimis finding was based on the proposed use, limited to one truck once a month and, maybe UPS twice a day, something like that.
Right.
What conditions limit the applicant to those?
So a board does not need to enter conditions for its decision to be valid. But in this case, and if you look at the planning board decision, it says it's incorporating in the proposed use, which includes the 3 vans a day and the 1 truck trailer a month. And it says if you go beyond that, you have to come back to the planning board for a change in that use, for a more robust use of the space. So you have to go back to the planning board. One of the issues we have here is the planning board decision was not appealed. And yet, in effect, that's what they're asking for.
Does the planning board decision carry with the land?
Yes.
And so I take it what you're saying is it doesn't matter that the planning board conditions were not also incorporated into the ZBA's use variance?
Not only is it not necessary, but in fact, that was beyond the scope of what the ZBA is looking for in trying to adjudge whether a use variance is appropriate under the Groundwater Protection Overlay District, which lays out its purposes, and those purposes are addressed, which is the protection of the groundwater.
Was there anything in the record, and I did not look for this, about the enforcement mechanism in the town of Northborough? In other words, if we were to look at Northborough's bylaws or whatever they might be, or regulations, I suppose, that there's a clear enforcement mechanism for not following the conditions imposed by the planning board?
I don't know if there's anything in the zoning bylaw to that effect, but that is how the statute works, the Zoning Act statute works.
Okay.
In essence, we are here because the appeals court came up with a highly speculative basis for determining whether somebody has successfully rebutted presumptive standing for the purposes of an aggrievement that is based upon the issuance of a decision. The basis for the appeals court decision was not raised at the trial court. It wasn't raised before the appeals court in its briefs. And they come up with it and cite a case that is not based on standing. And it, in fact, supports the position that I'm taking, because in that case, the portion that they're citing had to do with the enforcement of a 2019 special permit. And what the appeals court said is, yes, the local officials were correct that the service of food and beverages at the bar, which was, the bar was permitted by the special permit, the food and beverages were considered in the grant of the special permit. And therefore, it was appropriate for them not to try for the local enforcement officer to allow it to continue. That is, to deny the request for enforcement, because the 2019 special permit considered and agreed or it allowed for the service of food and beverage as a bar. As the appeals court said, it would be nonsensical to grant a special permit for a bar and that not allow food and beverage to be served at the bar. And in fact, the consideration of 2 extra chairs at the bar was because the local special permit granting authority was considering service of food and beverage at the bar.
Can you just help me out on, look at the actual decision. Where are the restrictions? Where are I just don't find, the conditions seem, I don't know where they are. If this guy goes, if your client goes out of business and the next person is Federal Express, what prevents Federal Express from operating in there? I'm just trying to understand that based on what the decision actually says.
So for that, I turn to the planning board decision.
But the planning, so does this thing anywhere expressly incorporate the planning board decision?
In fact, this occurred before the planning board decision.
Okay, so this, the planning board decision, is the planning board decision in the record? I haven't read it.
Yes.
Okay, and what does it say?
So the planning board decision, and you can find it, it starts on page,
I think it's RA 284.
Yes, it's also at 293. It's many places in the record. But yes, it does say approval is for the project as presented. This is in the decision itself. And it says a change from the application approved would require coming back before the planning board to apply for a modification of the special permit.
You have to come back to the planning board, again, back to Justice Wojciech's question, you wouldn't, and then you would have to go back to the ZBA after going to the planning board, or just the planning board?
So you
Approved a 20,000 square foot warehouse, right?
Right.
That's why the appeals court is jittery.
I guess that's why they're jittery. I don't see it as, an enormous warehouse. I don't think
Well, but
that's in the
20,000
record.
square foot warehouse, if it's Federal Express or somebody like that, that's a lot of cars. But you're telling me because of the planning board decision, that can't happen?
That cannot happen. And I'll submit by the ZBA decision as well, which is based on the proposed use as presented. That is the limitation on the use of this property. And the planning board has made it clear that a change is going to have to come before the planning board. And if it does, the Stone family will have an opportunity to appear and object. And if there is a change that is permitted, they can come back and come to court and seek review of that decision. Nothing further unless there's further questions. Thank you.